Hey guys, I'm gonna
Hello,
start.
hello.
Okay, good afternoon, everyone. Can you guys hear me fine?
Yes, I can hear you.
Okay, great. Thanks everyone for dialing in today. My name's Emmanuel Sylvester, and I am the chairperson for programs at the Nigerian Professional Group, and I'll be your moderator for today. So I guess today's session promises to be very insightful because what we're going to be doing today is sort of demystifying the permanent residency process in the United States, right? But it's going to be with a very specific focus on the EB visas and H-1B visas. And you guys will be hearing from seasoned professionals in the field. So we have some seasoned immigration lawyers on the call today. And then we also have some individuals who have gone through the process and will be sharing their personal experiences as well. So yeah, before we get right into the presentation, I guess I would like to call on Babatunde Raimi to give the opening remarks. Babatunde, are you on the call?
Yeah, when I'm here.
Okay, yeah, so you can take it from here.
All right, thank you, Emmanuel. Good afternoon, everyone. It's actually a pleasure to welcome you to today's webinar hosted by MPG, and actually on a topic that is pivotal for many of us as international students and professionals. Navigating U.S. immigration inside on EB2, National Interest Waiver, and H-1B visa. It's something that we really need to know about. We know most of you could have probably heard about it, but you still don't know how or which way to go about it. That's why we organized this event. The landscape of U.S. immigration is very complex, as we all know, and it's ever evolving. So presenting both opportunities and challenges that can significantly impact our careers, also our personal lives in the United States. So it's important for us to understand this pathway, whether we are students nearing completion of our studies, or professionals to seeking to expand our horizons, or entrepreneurs, aiming to start a new venture in the United States. So today, we will explore two critical avenues: the EB2 NW and also the H-1B visas. The EB2 NW offer pathways to U.S. residency that bypasses the traditional employer sponsorship requirements, which many of us have as a challenge. So instead, we're focusing on the broader benefit of your skills that could, be more beneficial to the United States. And on the other hand, we're also going to be talking about the H-1B visa, which is also a very popular route for professionals and students with specific occupations looking to gain special work experience in the United States. So our discussions will provide you with essential insight into navigating these processes, from legal analysis to practical advices on positioning yourself as an ideal candidate for either of these opportunities. So thank you for joining us. I look forward to an engaging and informative session that provides you with enough knowledge to make informed decisions about your immigration journey. Thank you so much.
Yeah, thank you. Beautiful, Babatunde. Thank you for that opening remark. And before we go any further, like I said earlier, we will be having some people who have gone through this process already share their personal experiences. So the very first person we would have share his experience would be Adedire Adesiji, and he would be reflecting on his experience with the EB2 NIW visa. Adedire, you have the floor.
Okay, good morning, everyone. Thank you so much for this privilege, MPG. So my name is Adedire Adesiji. I am also currently the finance chairperson for MPG. And so I'd say that the first time, so what I do, I'm based in Boston. I'm a PhD student at Boston University and Department of Mechanical Engineering. So basically what my research revolves around is using intelligent systems, robotics to accelerate material discovery or material research. So we've discovered over the years that material research is slow. So how can we speed that up? So my journey with the EB2 NIW actually started, well, I knew about EB2 NIW in like summer of last year. And because a lot of times, what people then would portray is you need an advanced degree to put in for the EB2 NIW. I knew definitely that at some point I was going to explore a permanent residence route. And so I decided to, learn more about it. And it was up until December, I just put it aside thinking, because I came in directly from undergrad. So I had my undergrad in Nigeria, University of Ilorin. And I just was right after NYSC that I came in here for my PhD. So I didn't have an advanced degree. So I felt, okay, let me wait until I finish coursework, like May now, and then get to my advanced degree so I can put in for the EB12IW. So I was just at home, going through the requirements, sometimes in December, after Christmas. And then I saw on the policy manual that you can either use an advanced degree or prove exceptional ability. So I decided to shoot for it, like, well, looks like because I think out of the 6 criteria, you only need to meet 3. And then I saw that I met 4 conveniently. So said, okay, let's shoot for it. I did it afraid, but, I put my application together. I actually wrote my application in 7 days. And then, before then, I was reading a lot of stuff online and studying the policy manual. So I then applied beginning of January, and about 4 working days after, I got a response that it was approved. So that's like, the compressed my story. And I would maybe just like to speak into, I know that we'll go deep into it with the seasoned professionals that we have here. So like the 4 out of the 6 criteria that I used was 1, I had a degree in the area of exceptional ability. So the area of exceptional ability, that because my background was mechanical engineering, but I was doing a lot of things with like AI, robotics, materials. So said autonomous material engineering, that I had exceptional ability in that. So proved that with my first degree, courses I had taken, my performance, all of that. And then also, because I didn't have years of work experience, so I couldn't do, the 10 years progressive work experience. But then said I was also a member of professional associations. I'd also done, I'd reviewed for top journals before, and then included that. So the criteria where it talks about how that, I've been recognized for significant contribution in the field, and also talked about that I'd received remuneration in the area of my exceptional ability, because as a PhD student, you receive some level of stipend. So, and also like invitations to speak relating to my area of exceptional ability. So just put all of that together to fulfill that part of exceptional ability, and also move to the NIW part, which, we have professionals here who will dig deep into all of that. So that was how I put my petition together. And also, I think one interesting thing was I didn't use any reference letters. But that's my story. And thank you so much for having me here.
Yeah, thank you very much, Adedire. If there's anything that I got from what you just said, it would be the fact that it's not absolutely necessary to have the advanced degree before you apply for the EB2 NIW. As far as you're able to prove exceptional ability, right, you should be good to go. Okay, thank you for that. Without further ado, I would like to invite our keynote speaker, Betty Akor. But before she takes the floor, I would introduce her. Her name is Betty Akor. She is a Nigerian attorney with over 7 years of experience in legal practice, academia, and socioeconomic policy research. She also holds advanced degrees in law and economic development and sustainable development, reflecting her passion for creating opportunities and connecting people with vital resources. As someone who successfully obtained the EB2 National Interest Waiver, Betty uses her knowledge to guide others through the U.S. immigration process while also working as a regulatory affairs specialist in higher education. Ladies and gentlemen, let's welcome Betty. Hi, Betty. It's so nice to have you on the call today, and thanks for honoring our invitation.
Thank you, Emmanuel. Hi, everyone. like Emmanuel said, my name is Betty, and today I'll be talking to you about the EB2 National Interest Waiver petition. And I prepared a slide deck that I'll share with everyone. So,
Okay, great.
all right, first slide, please.
Lydia, next slide, please.
Right. So, like I said, I'll be talking about the EB2 National Interest Waiver petition. So the EB2 is an immigrant, an employment-based immigrant category, right, that you can apply for if you meet certain criteria, right? So the US generally has different kinds of employment-based visa categories, right? We have the EB1, EB2, EB3, EB4, EB5. Or specifically, the EB2 is the second preference, right, of these employment-based visas. And so again, it's a pathway to getting your green card. Like I have here on the screen, it's an employment-based green card that allows you, sorry, forgive me for that, that allows you to self-petition for a green card. So you do not need a sponsor, you do not need an employer to sponsor you. So ordinarily, for you to get an employment-based green card, you need an employer, who would provide a job offer, or you also need to go through the labor certification process. But then the National Interest Waiver is basically telling the USCIS that you have certain kinds of skill sets, right? Or you have this background that merits a waiver of that job offer requirement or the labor certification requirement. And if you're successful, if your petition is successful, that's a pathway to get your green card for yourself and any other person that is any other dependent, your spouse, your kids. But then one thing that I want us to note through this whole process is that the EB2 is a discretionary benefit, so as we, talk more about this, I'll expatiate on how that's a discretionary benefit. So it's not as of right? So that you have certain requirements doesn't mean that you necessarily would get an approval. Lillian, next slide, please. Next slide, please. All right, so the next slide, we're talking about eligibility requirements. So what do you need to be eligible to apply for this national interest waiver? Like, was it Emmanuel shared, right? You need an advanced degree. That's the first eligibility requirement, right? So it's either you have an advanced degree or exceptional abilities, right? In the sciences, arts, or business. So an advanced degree could be a PhD, could be a master's degree, or it could be a bachelor's degree with more than 5 years of progressive work experience in the field, right? You could also have exceptional abilities in like whatever area of endeavor that you currently practice. I've seen a chef gets approved based on exceptional ability. The persons who have other, would I say awards or some kind of achievements or accomplishments who would qualify under this exceptional ability. So there's 7 criteria that you need to establish if you're going under this exceptional ability, like criteria. That's obviously held to a higher standard of like your application will be reviewed with a more strict or under a strict, more standard, right? And then if you have an advanced degree, exceptional ability, the next thing that you need to do is to meet the 3 prongs at the end of you. So the first prong is that you have an endeavor that has substantial merit and national importance. The second prong is that you have to demonstrate that this endeavor that you're proposing, right? You're well positioned either academically or professionally to advance that endeavor. And the last prong is that you need to show you have you need to show that on the balance, it would be beneficial for the United States if they waive this job offer requirements, again, because that's what the whole NIW is hinged upon, right? There's this labor certification requirement and there's this job offer requirement. The next slide. So I think I can just continue. Yeah, so I'd walk us through the different prongs, just explain more on the different prongs. So the first prong that I mentioned is substantial merit and national importance, right? So that prong basically addresses the future or the potential future impact of your endeavor and its national importance to the United States. So there are different ways you can establish national importance. I think a lot of people tend to focus on substantial merit. You know, you talk about how important your field is or what you're proposing is. Like, you focus more on you and not the country or how it benefits them. So there's a high chance that you're going to miss, you know, addressing that point of national importance. It's very critical here. Thank you. Right, so there are different ways to establish merit and national importance, right? So one way is that you're saying that you have this endeavor that has positive economic effects, so it has strong economic impacts, right? Or it has that potential to generate strong economic impact, right? And you can also propose an endeavor that improves the well-being of people in the country, the American people. You know, it could be socially, culturally, or some other way, right? You could also propose an endeavor that has the potential to employ people in the country. You could also propose an endeavor that enhances U.S. national security. So that's it for substantial merit and national importance. The next prong that we will be discussing is the well-positioned prong. So that prong basically addresses your educational and professional background, like I said earlier. So you submit evidence that is related to your education, your work experience, your skill set, right? And any other evidence of past success in your relevant industry. You also can provide details about any future plans, like if you have a business plan. A lot of people would most likely want to set up a business, or they plan to pursue a PhD or anything. Those are ways you can demonstrate your position, you know, a plan for future activity, because you're saying that, okay, this business plan or this PhD that you intend to pursue would better position you or would equip you with certain skill sets that you need to advance your endeavor. You can also get letters of intent or other expressions of interest from prospective clients, investors, customers, to show that you're well positioned. You know, there's an interest in what you're looking to do. Then the last prong would be for you to demonstrate that on the balance, it would be beneficial to the United States if they waive this job offer requirement for you. So there are different ways you can establish that. I like to tell people that it's more of a summary of the first two prongs, right? So you're basically summarizing the points you've made in the first two prongs. You're saying that, okay, you have this endeavor that is of national importance, right? So you're emphasizing the national interest in what you're proposing. You're also you're further like reiterating your positioning, right, to advance that endeavor. So you also need to make a case for why it would be impractical for you to secure a job offer, right? So for persons who are self-employed or entrepreneurs, this is like the NIW is the best way for you to get your green card. Well, one of the ways you can get your green card, because it is impractical for you to actually secure the labor certification or a job offer. You can also provide evidence, you know, that even if they're like other qualified U.S. workers, that the U.S. would still benefit, you know, from your contributions to the country. So, for example, if you have a record of past success in whatever it is that you currently do, you can advocate that, you can put that forward and say, okay, you've done this in the past, right? And it was successful, and you have the ability to replicate this success in this field, right? Or with the endeavor that you're proposing. So that's it for the last prong. The next thing that I would talk about would be expert letters. A lot of people ask questions about, you know, what kind of letters they should get or who they should get letters from. So you need letters of support. You need letters from people, experts in the field, to support your qualifications, your exceptional ability, to support the endeavor that you're putting forward. And these letters generally need to speak to the contributions, right, of the potential contributions of your endeavor, the potential contributions of the endeavor to the field, to the country, the national importance, right? Because, so look at it as an expert opinion, you know, like someone providing this objective evaluation of something you're proposing, right? So it's most times, if you're talking about an objective evaluation, you need letters or you need someone who doesn't know you personally. So you're not necessarily getting a letter from someone who knows you, someone whom you've worked with, right? So you can reach out to experts within your field. You can find them on LinkedIn or ask someone to refer you, right? And then they evaluate this thing that you're proposing and then they offer an opinion or they write down their opinion and you can submit to the USCIS. So you can get letters from your professors, your past employers, your clients, government officials, political figures, or other well-known persons in your industry. The next slide, please. So I'll just briefly touch on common mistakes and misconceptions about this whole NIW process. The first mistake, I believe, is working with people. The first mistake that I've noticed is that people propose an endeavor that only favors the current employer. So you put forward an endeavor that shows that you plan to remain, with the employer that you're with. You're just looking to improve their processes, right? Or you're looking to do something that benefits the employer and not the national interest. So that's a common mistake. You're sure going to get either an RFE, and RFE is a request for further evidence, or you're going to get a denial because there's no national interest there. The second mistake is focusing on your qualifications, your credentials, your achievements, right? And not national importance. Again, the USCIS places a lot of emphasis on national importance, right? So a lot of people have, they have several awards, they have, good credentials, things they can brag about, right? But then they fail to actually talk about how this would benefit the United States, right? They tend to forget that again, you're saying that this waiver is in the national interest. So whatever you do, always make sure that you focus on national importance, right? Common mistake number 3, no well-articulated endeavor. So you do not have an endeavor, you just write just like a prose without a beginning and an end. So the person who is reading the adjudicator who is reading your petition would want to see what exactly are you proposing, right? So we know that you know what you're doing, right? Not that you just pen whatever comes to your mind. No, you need to have something. You need to put together a detailed endeavor, right? And then the last common mistake that I've seen is insufficient documentations, right? So I've read some decisions from the USCIS, that's the AAO, Administrative Hearings Office. And then they talk about how people just make assertions that they cannot back up with any evidence, right? You don't have documents to prove what you're asserting. So you can't just claim to want to do something, or you can't say you want to do certain things, or you have certain qualifications without backing it up with evidence, right? So the next thing is misconceptions, common misconceptions. Number 1, that you need publications and citations. No, you do not need publications and citations. Like I said before, I've seen a chef get approved, right? I've seen persons with publications. I've seen a guy actually who had several publications get denied. He had like a solid background, very good background, and he still got denied, right? And I've seen people without any form of publications also get approved. Second misconception is that only STEM degrees qualify. So you do not need to have a STEM degree to qualify. If you have your degree in the arts, social sciences, humanities, or whatever, you still qualify. The third misconception is that you qualify simply because you have an advanced degree. That is not true. You need to put forward a very persuasive and compelling argument for why you merit a waiver in the national interest. And then the last misconception, which is very important, is that the national interest waiver confers an immigration status. And a lot of people get into trouble. I mean, I work with people who, come to me and they tell me, oh, they thought, filing the NIW would confer some kind of immigration status. No, it doesn't confer any status. You need to be invalid. You need to be in status for you to apply, or for you to even get to the green card, to get the green card you're looking for. So when you submit your petition, the USCIS would not tell you that you're not in status. It is for you to figure out. They will approve your petition. They have no problem approving it. But when you get to the green card stage, then you see that, you've been out of status and they deny your green card. So the next slide. My time is up, but I'll just quickly run through how to apply for the NIW. So the first step is for you to file your I-140 petition with the USCIS and submit your supporting documentations. We have the concurrent filing, which currently is not available. And then we have the standalone filing, which you can do. So the standalone filing basically is just you submitting your I-140 petition. And concurrent filing is you filing your I-140, that's the NIW petition, plus your green card application. And we have the standard processing, the premium processing. Like some of you know, standard processing is cheaper or slow. You tend to get a decision within six months to 2 years, it depends. And then premium processing, that's faster but more expensive. But then you should also know that premium processing does not guarantee an approval. And the USCIS may deny, approve, or issue a request for evidence on your petition. Next slide, tips for success. Number one, clearly define your endeavor. All right. Tips for success, number one, clearly define your endeavor, right? So like I said before, you need to have a clearly defined endeavor. You need to state, what is this endeavor? You know, I'm looking to do this, right? It could be a research you're proposing, right? It could be a business you're looking to start up or something. You need to have that thing clearly defined. Just have it like the first thing they see in the first paragraph, that endeavor. This is what you intend to do. Just like you have a problem statement, you know, if you have, you're writing a dissertation or thesis, you have a problem statement, you have a topic, right? So you need to have something clearly defined, right? Number two tip for success, address national interest, national importance. You know, most of the denials that I've seen, you know, is hinged upon this failure to address national importance. So you need to emphasize the benefits that your endeavor brings to the United States. You need to get good letters of recommendations, right? Not people just talking about how hardworking you are, how punctual you are, or, you know, get letters that actually address or speak to the prongs of the NIW. And also organize the petition packets properly. You know, a lot of people just mix things up and send to them. If you make their work easier for you, they're most likely or more likely to make your work easier for you too, you know. Then the last thing that I have here, next steps following the decision from the USCIS. If your petition is approved, you know, then you may file a green card application through either adjustment of status if you're within the United States, or consular processing if you're outside the United States. If your petition is denied, you have a few options that are available to you. You can file an appeal, submit a motion to reopen or reconsider, reapply with a new application, or seek alternative immigration options. That is all. If you have questions, please let me know after this. Thank you very much, and God bless you.
Oh,
Okay,
we have
yeah,
one
thank-
question.
Yeah, so we'll have to save, because we're running behind on time, we'll have to save the questions for after everyone has given their presentation as well. So, okay, yeah, so I'll save the question. You can ask it much later once the second speaker is done. Okay, so just to sort of wrap up what Betty said, I think the most important thing I took out from what she just gave was that you, in order to get approved for the national interest waiver, you need to satisfy 3 prongs. The first being, you need to show that your work is of substantial merit and national importance. You need to show that you are well positioned to advance the supposed proposed endeavor. And thirdly, you need to show that on the balance, it would be beneficial to the United States to waive the labor certification. Okay, so on our agenda, I am actually next. So I will be sharing my own personal experience with the H-1B visa, right? But before I go ahead to say anything, I just want to make sure that everyone understands that everyone's experience would be sort of different. You know, people would have different experiences with the H-1B visa. And you sort of have to chart your own course. You know, luckily for me, I sort of had it easy. Most people typically don't have it easy with the H-1B visa. So now I'm going to be sharing exactly what I did, but this is by no means an invitation for you to follow suit. Like I said earlier, you would have to chart your own course and just do what's right for you. Right. So when I initially started looking out for opportunities after grad school, I wasn't necessarily looking out for one that was going to sponsor my H-1B visa, right? Because at the time, I just wanted a foot in the door. And you would notice that when completing the application to most of these companies, there is a section that would typically ask if you will be requiring a visa sponsorship from the company or not. I mean, while it is great to always answer honestly for those of you who really are in need of the sponsorship, what I quickly realized that there was sort of a bias towards people that answer honestly. Some companies would use that as a criteria to screen out candidates out of the hiring process, limiting your chances at securing a job, right? So for me at the time, I still had my 3 years OPT intact, so I wasn't necessarily looking for a H-1B sponsorship. So what I did right off the bat was always to answer no to this question. So if they ask if I needed visa sponsorship, I would say, no, I don't need visa sponsorship. So that sort of increased my chances of securing a full-time employment, which I eventually did. I think barely 2 months into my job, when my boss, my direct line manager, and my director did see the value I was bringing to the company and to my team, they were the ones who reached out to me and asked if I wanted to pursue the H-1B visa. And of course, I jumped on the opportunity and I told them, yeah, I'm actually interested in the H-1B visa. And so we went ahead to file earlier in the year. I think it was around March. So the first raffle that happens with the H-1B visa happens sometime around March. So I wasn't selected in the first pool, but subsequently there was a second draw later that year, and I got selected in the second draw, and which is how I ended up getting my H-1B visa. So ultimately, I believe the take-home experience from my own experience is that you want to make sure that your employers see the value that you bring to your team, and regardless of how much it costs them to file for the H-1B visa, they'll be willing to pay that price just because you're bringing some value to the team, right? So yeah, that's my own experience. Anyways, moving on to the next agenda for the day, I'll be inviting Olubunmi Olotu, who's our second expert speaker. Attorney Olubunmi Olotu brings over 17 years of experience in legal counsel with a clientele ranging from high-profile individuals to government agencies and businesses. She specializes in privacy, risk management, and litigation, providing strategic solutions that meet clients' needs. She currently serves as the Assistant General Counsel at the Massachusetts Department of Mental Health, and Olubunmi is recognized for her comprehensive legal expertise and exceptional results in immigration law, and through working with nonprofit organizations and her own boutique law firm. Olubunmi, welcome and thank you for honoring our invitation today.
Thank you for having me.
Yeah, you have the floor now.
Thank you so much. Thank you everyone for having me. I hope everyone's having a good Saturday afternoon so far. So let me get right into the H-1B generally, because I know time is very limited and I have a lot on my slide, which I'll probably just run through quickly. So what is the H-1B visa? So the H-1B program allows companies and other employers in the United States to temporarily employ foreign workers in occupations that require theoretical and practical application of a body of highly specialized knowledge, and a bachelor's degree or higher in the specialty occupation is required, or its equivalent. Okay, so what is the H-1B visa? Again, continued. Again, as I mentioned, you need a specialty occupation. This includes fields such as architecture, engineering, mathematics, physics, physical science, social sciences, medicine and health, education, business, accounting, law, theology, and the arts. So you can't be someone that's you can't be delivering pizza delivery person, because that's not a specialty occupation that requires a bachelor's degree or higher. So that's a very strict requirement. And this visa is a dual intent visa, meaning that it's a non-immigrant visa and also an immigrant visa. Visa, which allows for the possibility of applying for an immigrant visa in the future, or just coming temporarily just to work in that position and then going back to your national country of origin, or whatever country you want to go to. And this is an employer-sponsored visa, meaning that this petition must be sponsored by an employer, and technically the petition must be filed by the employer rather than the employee. And the employer, is also supposed to pay for the application as a business expense. And again, this is a professional level job. So the position must require the skills and services of a professional, and the worker must have professional credentials to fill it. And again, as I mentioned, the educational level minimum is a bachelor's degree in the field of the proposed employment. And so a minimum, so it could be a master's degree, but at a minimum, the job has to require a bachelor's degree. And that means that just because I want to hire you as someone that makes pizza in my shop, I can't say that you need to have a bachelor's. I can't post a position stating that you need a bachelor's degree, because we all know that technically you don't, it's not a requirement to make pizza. So you can't pull that trick to get around it. And there has to be an employer-employee relationship. The employer relationship must be defined by a contract or an employment offer letter, which specifies the terms of employment, such as job titles, duties, dates, salaries, and benefits offered. And with this visa, the period of stay is up to 6 years. So you can do at a 3-year increment. So 3 years, and then you can extend up to 6 years with some exceptions. Okay, so there's a cap. I'm not sure which slide you're seeing, but so there are 2 types of H-1Bs. There's one that are from cap exempt employers, and there are ones with employers that are capped. So the current annual limit of qualified foreign workers who may be issued a visa is 65K. And then there's an additional 20K for individuals with advanced degrees, so a master's degree from a U.S. institution of higher education, they have an additional 20K. And then the cap exempt employers, these are institutions of an example of a capped exempt employers are institutions of higher education or its affiliate or related nonprofit entities, a nonprofit research organization, or government research organization. And so individuals who have worked with in the past that have had positions, that have secured positions from cap exempt employers are typically foreign medical graduates or international medical graduates. And dependents. So when you have when your H-1B visa is approved, your dependents are also provided status. So your dependents, children and spouses under the age of 21 are eligible for H-4 status. However, the H-4 status only allows you to live and study in the United States. So you can study as a student, you can live here, but you are not permitted to work, except in limited circumstances, which that might include if you have a pending green card application. So again, the position requirement. So again, it has to be a specialty occupation, and the position must have one of the following criteria to qualify as a specialty occupation. It must require a bachelor's degree or higher. The degree requirement is common in the industry. So again, if it's not common for a bachelor's degree to be required, then the job would not qualify. And the nature of the specific duties have to be they're so specialized and complex that the knowledge required to perform the duties is usually associated with the attainment of a bachelor's degree or higher. And then the employee requirement, the employee themselves must meet the following criteria. They must hold a US bachelor's degree or higher degree required by the specialty occupation. They can hold a foreign degree that's equivalent to a US bachelor's degree or higher. And in some cases, they have to hold an unrestricted state license to practice in that field. So the application process, there's cap season, which starts in March of the fiscal year before you're starting your employment. If you're working for a cap subjected employer. So you must register for a cap application, and the employer must register each beneficiary associated with that they want to file for that's subject to the cap. And the registration fee is $215 for this year. And again, the CAP season starts in March and it runs for 2 to 3 weeks. And you cannot file your petition unless you've been selected as unless you've been selected in the registration process. And when you are selected, you may file your petition within 90 days, but no sooner than April 1st. And it can't be any more than 6 months before the start of the employment. And typically the employment has to start on October 1st. If you're capped, if you're working for a capped subjected employer. If you're capped exempt, you don't have to do any of this. You can apply at any time. And you can start working at any time. So I'm just gonna run quickly through the application process. You need to fill out and submit a Form I-29, petition for a non-immigrant worker. And you need to include the H classification supplement and the H-1B data collection and filing fee exemption supplement. You must indicate in the application that the start date will be October 1st or later, or your petition will be rejected. This is if you're applying for a CAP subjected job. And you must provide a copy of the H-1B registration selection notice filled by your organization on your behalf. You must submit evidence of the beneficiary's passport. And all the information that you submitted must match what's on the petition. So all the information that you submitted during the registration process must match what's on the petition. You have to make sure that each form is properly signed. Required fees may be paid by check, money order, or credit card. And you have to submit all required documentation and evidence with the petition. And then you have to also submit a labor condition application. It has to properly correspond to the position in the petition. And you have to submit evidence of the beneficiary's educational background as well. The timeline for approval. It takes about 5 to 8 weeks for approval if you do regular processing. With premium processing, it takes about 15 days. And again, as our other speaker said, just because premium processing just expedites the processing. It does not increase your chances of being approval. So your application has to be on point, and then you expedite. If it's expedited, if it's something that they're going to approve, it just gets it approved faster. If it's something that they're going to deny, it gets it denied faster. And you can upgrade your application to premium processing at any time. So if you find that if you already submitted your application and you find that it's really slow, you can just go ahead and opt to upgrade your application. And you can choose, so depending on where you are, if you're located outside of the country, you can opt to have consular processing with the National Visa Center. Or if you are in the US, if you're in F1 status on OPT, you can apply for a change of status through the I-539 application. You can actually do that at the same time as you're filing for the H-1B application. You can file it as a joint application, or you can do it after it's been approved, either one. And then strategies for a successful application. I think it's very important that you consult and seek the advice of a qualified attorney, because this is a very nuanced area of law. There's so many small facts, so many small details that go into it, so many exceptions. So I think it's important. And also, like I said, it's an employer-sponsored petition, which is supposed to be carried out by the employer. However, I think it's also important. Beneficiary and employee can also seek the advice of an attorney, because you want to be prepared, because as the speaker that went right before me mentioned, a lot of employers don't want to do this. They feel like it's a lot of work. If they're not used to doing this a lot, they don't typically want to do this. So it's crucial for you to be, if you're prepared, if you are an outstanding employee, it's good for you to be prepared and say, listen, I know these are the things that I need to do. I know a lawyer who can help us get this process done. So being equipped, being able to serve as your own advocate, I think that's key in this situation. and also next point is make sure that all the jobs meet all the qualification requirements of a specialty occupation, and that you as a beneficiary meet all the qualification of the job that's demonstrated through your, and that this is demonstrated through your application. And I think it's also ideal to apply for a job through the OPT if you're in the United States. If you're here at F1, it's awesome to do OPT because, as the previous speaker mentioned, as you're doing OPT, the employer gets to know who you are. And they're like, oh, we love this employee. We want to do whatever we can to keep them on for as long as possible. So that's a great way to make sure that you have a successful application. And you can build a relationship with the employer and they will in turn file for you. And the benefit of doing that is that you can continue to work here in the US while your application is pending. And then another tip is if you want to make the cap, if you want to have more chances to get the cap, is to be chosen, is that you should have a master's degree, a US master's degree, because that will give you an opportunity for an additional 20K. So, and then another tip is just to avoid the cap altogether. Apply for a job at an employer that is capped exempt. So again, that's institution of higher education, nonprofit research organization, or government research organization. And that's all. That's all I have. Thank you so much.
Thank you so much, Olupumi, for that very insightful session. And just to reiterate some things that she had said already, in order to apply for the H-1B visa, you must have a specialty degree. The H-1B visa can be renewed for up to 6 years. And everyone would have to go through the raffle process, except you are with a cap-exempt employer. Right. So, yeah, so thank you. That was very insightful, Olupumi. Now we'll be going into the questions from the audience. So if you have any questions to ask our speakers, you can just put your question in the chat box or just raise your hands and I'll unmute you to ask the questions. Are there any questions that I missed in the chat
So
box?
first of all, we have a question in the chat. Yes, there's one question. If you go to the beginning of the chat.
Okay.
From Bolahan.
Oh no, I don't think that question is. Yeah, that question is not tied to today's talk. Right, he's asking if someone in the UK can get a scholarship to do a PhD in the US. Yeah, it's not tied to this conversation. So, Adedire, can you unmute yourself and ask a question?
Okay. Yes, thank you so much for the insightful sessions, Betty and Bumi. So I was going to ask, usually like Betty said, that the approval of an I-140 does not necessarily have any immigration benefits until you have your adjustment of status filed. I know a lot of people are right now in the situation where, let's say, they have the I-140 approved, pending the time that the visa priority date becomes current. Some people say you cannot show non-immigration intent after you've shown immigration intent. So for instance, an F1 who has an approved I-140 that means the person won't be able to renew the F1 visa, which let's say for a Nigerian would be 2 years. So that means you have to wait until your visa priority date becomes current. So I just wanted to know if you could shed more light on if there is any, at least travel benefit or like maybe visa renewal options that one can go through pending the time that the visa bulletin date becomes current.
Thank you, Adedire. So the I-140 is, like I said, just an underlying petition. It's a petition, it's not a visa, right? So it doesn't confer any kind of benefit. So right now, due to the backlog, what people are doing, I mean, I've seen people who do concurrent filing, you know, so because ordinarily you should be able to file concurrently and request your travel document, right? So what some people are doing right now is they just go ahead and submit everything together, and some persons are getting their work done, the travel documents or the work authorization approved, and other persons are not getting any approval. So it depends. I really don't know how or why USCIS is operating that way, but then it's happening. As to if someone on an F1 visa, can attempt to renew their visa. So it depends, right? You know that USCIS functions separately or differently from the border control, right? So you might be able to leave the country, right, and get your visa approved. And then coming back into the country, border patrol might be like, okay, they won't let you in. And then there's that complication. But ordinarily, they should let you in. That should not, because you should be able to come back into the country. But I cannot guarantee that, right? Like whoever is in that situation should consult an experienced immigration attorney, yeah.
And I think I want to say that I think the issue that we have is really when you get to the adjustment of status stage. So if you're out of status, you've been here unlawfully, that's where your issue would be, because the NIW waiver the I-40 doesn't confer you any benefits while it's pending. So you would have to figure out a status that's valid during that time. So you want to make sure that your green card, it's almost like, your F1 is valid for that period. I would not advise you to leave the country and try to risk it and come back without permission to do so. So I think it's an ideal situation would be a time when your F1 is current or you have time, you're in status.
Okay, so if I got you correctly, that means for like an F1, the person should still stay back in the country and not try to go out and renew the visa.
Yes, exactly.
Okay. And then also Betty mentioned something about how that you can file concurrently for the EB2. I actually thought because it is not the bulletin right now, it's not current, then you can file concurrently except for like EB1 in some cases for certain.
Like I said, I do not know why or how the USCIS are currently operating. So for some persons, there are a few persons that have gotten their work authorization documents approved because they filed concurrently. And then there are persons who, like a lot of people have applied and did not get any approval. However, like I said to someone, you need to be careful, right? Because that you got the work authorization probably just means that it doesn't really mean anything. You need to be sure that your green card is validly pending. Because if you run out of status, when you get to that green card stage, that's when they tell you all the crimes you have committed. They won't tell you nothing right now. They can approve your work authorization, they can give you travel documents and all that. But you want to be on the safe side. It doesn't mean, because again, like you rightly said, there's a backlog, right? So ordinarily, you're not eligible to apply for a green card. But then if it so happens that they approve, some of your other documents, right? I would not say that, I would say you should be careful. You should still be careful. Yeah, I have someone, a wonderful, smart person, with she had an approved NIW and currently facing, like deportation because, she's overstayed her visa. She's not longer in status. So you just want to be careful, and they won't tell you anything.
Okay.
Sorry.
Sorry, Babatunde. Do you guys mind if we extend this for maybe another 10 minutes or 15 minutes? Just so we can have enough time to address all the questions that are coming in. Yeah, Babatunde, I hope you guys don't mind. If you don't mind, you can just say so in the chat box. Okay, no replies. Well, Babatunde, go ahead and ask a question.
Yeah, thanks a lot, Emmanuel. Thanks a lot the detailed explanation about the status. My question also is very similar to that of Adedeji, but in terms of status, right? So for someone who has an expired F1 visa or is currently on OPT, let's say the first year OPT or STEM OPT, does that keep the person on status even though the F1 visa has expired? That's the first thing. And secondly is, can the person who actually got the NIW approved travel out of the country and probably is coming back and his F1 visa, because it's not advisable to still have the F1 visa renewed because you already have an I-40 approved, right? So, but the second question is, can that person who is coming back into the country still be able to come in, even though the F1 visa is expiring like 2 days before? Let's say the person's visa is expiring on the 15th of June, but the person have an approved I-40, right? And the person is coming back to the United States June 13, even though the F1 visa is expiring on June 14. Is it okay for the person to travel out, or the person should just stay back in the country since they have an OPT and just not worry and wait till they file for their green card?
I'm sorry, can you repeat that? It was kind of long. So the first step is the person they're an OPT. They have an expired F1 visa, but they're an OPT.
Yeah.
So that means so you're lawfully in OPT. But your visa expired. Okay, that's fine. So you're here lawfully.
Yeah. So you have the OPT, which means you have the EAD card to work and all those stuff. So does that also mean that person is still in status, even though the F1 visa has expired?
Yes.
Right.
You're still in
and
status.
the second question is, the person who has the F1 visa, let's say you still have F1 visa, right? But the F1 visa is expiring, let's say on June 15th, right? And the person has an I-40 approved already, the NIW approved. So, some say it's not advisable to renew the F1 visa because you already have an approved I-40. So is it okay for the person to travel out of the country and return back like 2 days or 3 days before the expiration of their F1 visa?
No,
or it's not okay.
Whenever you have a pen, unless you have a travel permit, it's never recommended that you travel outside the country while you have a pending petition. I don't care. It doesn't matter if it's a family-based petition, employment-based petition.
Yeah.
Do not travel unless you have parole. So that's
and if you sorry, Betty, and if you look at the EAD card that's usually being provided to you, there's a place where it says this card is not valid for re-entry into the United States. Right. So once the F1 is expired, you're in status if you're still in the United States and your OPT is active. But once you leave the borders of the United States, you're playing way too close to the lines.
I would not recommend travel.
Yeah, I would not recommend it.
Oh, okay. Thank you.
Yeah.
Are there any other questions?
Yes, I have a question. I raised my hand up a few minutes ago. Maybe you missed the hand.
Okay, please go ahead.
Okay, from the very first question about leaving the country when you have your NIW approved, I just want to confirm something. Does it mean that the best plan of action would be renew your visa and then apply for NIW, get it approved? And then with that, because you already have a renewed visa, you can still leave the country and come back, even if you have an NIW approved. Is that the best plan of action? Or is it that if I have an NIW approved and I have a visa with so many years in it, I still cannot leave the country? So that's my question.
So one thing that I'll tell you, with this whole visa thing, so look at your visa, right, as a key to enter into a house, right? So your visa allows you to enter the country, exit. So you must have an underlying, there's a basis for you to stay. It's either your I-20, sorry, or you have something else that allows you to stay legally in the country. If you had like a validly pending green card application, that would toll it will toll whatever status you have. If it's F1 or something else, it tends to toll that, right? So it still keeps you in status. But like the whole thing with the visa, you need to look at your underlying reason, for being able to stay in the country. Is your I-20 valid? That's before you even address, the visa validity, right? You need to be sure that you're in valid status in the country. So if you have a valid I-20, you can exit the country. You need to get approval from your school, International Student Office. They're going to sign your I-20. So that lets you travel out and come back into the country. Or if you don't have like something that keeps you in the country legally, then you would have issues exiting and coming back into the country.
Again, I personally think that if you have an application that's pending, even if it's approved, I would not recommend travel and coming back in the country, because it could be considered abandoning your application. If you're saying I'm leaving, so I just be careful with that. Again, I think it's fact specific. It depends on the situation and circumstance. I think it's really hard to answer general questions without knowing all the facts, because you don't want to follow advice that I may tell you something and you may think you do it, but I don't know your whole situation. So just be cautious of that as well.
Yeah, it's also very tricky. I do have a personal experience, not from me, but from like a very close friend, where he was in good standing. He had his OPT active, but because he wanted to attend a family member's wedding in Nigeria, he left the country to renew his F1 visa while his OPT was still active, right? The visa got denied in Nigeria. But he was just very lucky that he was able to, he still had an active UK visa. So he had to go to the UK and reappeal, right? This is someone who's in good standing, who has a job in the United States, who's settled in the United States, but went back to renew the visa, right? I'm not saying, people renew their visas all the time. It's possible, but like, if you have anything pending over here, it might just be very safe to just stay till everything is sorted out before you can go about your traveling,
I think that's like a life sentence. Just keep somebody somewhere and the person is not able to move. What if I want to get married? What if I have something I have to do? I have a conference, I have a deal, a contract signed outside of the country. It just means I have to stay here because my NIW is approved, but I haven't been given the labor certificate yet. So just have to stay where I am. Wow. I don't know. But it's fine. Thank you. Thank you for answering the question.
So I just want to quickly add that with the NIW, right? Like I said previously, you could do a concurrent filing, but right now it's more of the standalone filing, right? So if you have a reason to travel, you can request a travel document. You just need to write to them and let them know that you have this, like you have circumstances that will warrant them expediting or approving your work, your travel document. So they have that, they have provision for that. You can apply and let them know that you need to travel for certain reasons. So it's not like you just need to provide evidence. If you have like, if it's a medical emergency, you submit documentation and they would approve it. So it's not like you're tied down, you just need to write to them.
Exactly. And they can approve or not approve at their discretion.
Yes, please. We have a question on the chat from Oniye Ibida. Please, how much does it cost? Yeah.
Cost for how much does what cost?
Oniye, can you be more specific? Is it the EB2 or the H1B?
If it's the EB2, I think it used to be around 1,750 or so, but it recently got increased. So for like the regular processing, I don't know, someone else can speak to it, but
yes, she just said
right. So for the NIW, so for the regular, for just NIW itself, it's $715, right? If you want to do premium processing, that's about $2,800 for premium processing and $715 for the NIW itself, the petition itself. So that's about $3,something thousand, right? Then you also have what they just recently introduced called the asylum processing fee, which is $300. So, you include that, that's close to, about $4,000, I think. And that's just for the NIW. Like when you get to the green card stage, that's another thing.
Okay.
And that's just today. It might be different.
Yeah, it might be different in a couple of months. And the administration is changing soon. So, just speaking. Okay, do we have any more questions?
Yeah, I have a question. Can I go ahead?
Yeah, go ahead, please.
Okay, my name is Toby. So I want to ask, currently on F1 visa, doing a PhD. It's an average of 5 years. I've just completed the second year. I want to apply
Okay.
for NIW, but before doing that, I want to renew my F1 visa next month, and then apply for NIW. I learned
Toby, you're breaking up.
and hopefully getting the renewal approved and then applying. Can you hear me? Can I go on?
Yeah, we lost you for a few seconds there.
Okay, so I'm saying that I want to renew my F1 visa. I'm still on the program. I still have on the average, about 3 years left on the program, but I want to renew my visa next month and then apply for NIW afterwards. And then I'm aware there's a waiting period. So my question is, after renewing my F1 and applying for the NIW, during that waiting period, can I use my valid F1 visa, renewed visa, to travel in and out of the country? And then there are these regulations around international students working like outside the campus, like job restrictions, right? Even if they have to use their social securities. Some say the trepidations are unfounded. You can do like independent contractor jobs. It won't affect your immigration application in future. You can do Uber and things like that. I want to know what your take is on that. Like, if you feel you need to work, even if there are like restrictions, they say don't work outside the campus or outside CPT, are there still things that you can do and won't affect your immigration interest in the future? Thank you.
Right, so I can take that. And I don't know who asked that question.
My name is Toby, Oluwatobi.
Oh, Toby. Yeah, Toby. So this is not, please do not take anything that I say here as legal advice. This is just general information, right? So if you are in F1 status, you're only allowed to work, maximum 20 hours on campus. If there are extenuating circumstances, that warrant you looking for a job outside of campus or outside of the 20 hours, you need to let the International Student Office know, and then they will do a request to the USCIS, and you get like an approval to work outside campus. So a lot of people may or may not do work without authorization, but when you get to the green card stage, if they find out, they're going to run a check when you get. So right now you can do so many things, they won't come for you. But at the time you apply for your green card, that's when they do a comprehensive check, right? They see that your name is coming up, because if you use your social security number to get a job, the employer is also reporting, any payments to the IRS, right? So at that point, USCIS normally would not pull information from the IRS, but at the green card or your citizenship application stage, they're going to do a check, and they see that you've worked without authorization, then that would cause problems for you, right? So I would say that it's better that you avoid it altogether than put yourself in that situation, and then start trying to resolve it much later. I don't know if that answers the question.
Yes, it does. Thank you. The second one is the first one I asked is, so if I have an active F1 visa, I'm still studying, but I apply for NIW. As long as my visa is valid, F1 visa, and the NIW application is in process or approved, and maybe I'm waiting for the green card approval as well, can I travel in and out of the US?
When you say you're waiting for the green card approval, do you have it pending? Like, have you submitted an application or yet to submit one?
That's what I mean, after submitting an application.
If you have a pending green card application, that means you've already demonstrated like immigrant intent, right? So you need to be careful. Your visa, you're demonstrating non-immigrant intent. So how do you defend that? So the common reasons for student visa denials or B1, B2 denials would be lack of ties, lack of strong ties to your home country, or lack of sufficient funds. So those are, you need to show that you have strong ties to your country to demonstrate non-immigrant intent. But now if you have a green card application pending, you cannot prove that you don't have immigrant intent. So you need to be careful, right? Again, you need to talk to an experienced immigration attorney, for more guidance.
Yes, and I would like to say one more thing to answer that question. I think we answered that question again regarding travel. When you travel, when your applications are pending without parole and authority from USCIS to travel, you are abandoning your application. You can be considered to be abandoning your application. So if you're leaving while it's pending, so get permission. You can always travel. You can always apply for parole to travel. You may or may not get denied. It may or may not get approved, but that's the best first thing to do. And again, I agree with Betty. Definitely consult with a qualified immigration attorney. They can answer your specific questions and guide you appropriately regarding your unique situation and circumstance.
Thank you.
Yeah, thank you very much. That's going to be the last of the questions. Thank you so much, Olubunmi, and thank you. No, we need to let people go. We've used an extra 15 minutes.
Yeah.
So thank you so much, Olubunmi, for honoring our invitation. Thank you so much, Betty. It's been such an insightful session. So now I'm going to be handing it over to for the closing remarks. Please, 1 minute. Thank you.
Okay. Hello, everyone. Thank you so much, Betty Ako and Olubunmi, for such an insightful session. And I just want to thank everyone, Emmanuel, Adidire, Lillian, Jide, everyone, and the whole board of the MPG for this opportunity to educate our international community, because this has been so educational. The questions, the answers from the keynote speakers, thank you so much. We really enjoyed. It was fun because I saw some very funny questions. Like I think someone said, "Don't tempt Allah," LOL. Like I think he was laughing at someone for wanting to travel. So like from this whole stuff, we should just be very, very careful with the decisions we take. We should consult an attorney because the immigration laws here are really tight. Yes, so I just really enjoyed the session. And then also, please also follow us on LinkedIn, the Nigerian Professional Group. Also follow us on Instagram, Nigerian Professional Group. And also, if you want to be a member, you could just check on Google and then you could just sign up. We have really educational stuff coming for you this year, so you don't have to miss out. Thank you so much. Have a good weekend. Thank you.
And this session is going to be available on the on our YouTube page, right? So yeah, you can check on YouTube for this session for those who would like to go over this recording in the future. So yeah, thanks everyone for coming. Do enjoy the rest of your day. Thank you, Betty. Thank you, Bumi. Bye-bye. Thanks, Adedire. Bye.